Good morning, everyone. I'm just going to wait a couple of minutes while the numbers come through. I think we've got about 150 on so far, so some good interest in this topic. My name's Kate Beneffer. I'm a partner in the Employment and Immigration team at RWK, and I'm joined today with two of my colleagues, Adrian Henderson and Sophie Waller. Now, we're going to talk through right to work checks, how to do it, why it matters, and then some tricky areas towards the end. Just before we do go into the detail, I'm just going to launch a quick poll, which will enable people who are still joining to pick that up as it comes in, just to get a bit of a understanding from us as to who's in the audience, what you know, what's going on in your organisation. So I'll launch that now and give it a couple of minutes for people to respond, and then we'll move on. Okay, so hopefully everyone can see the poll on their screen. Just a handful of questions. So firstly, has anyone ever received a penalty notice? So yes, if you have, no, if you haven't, and you may not know. So this is a penalty notice for employing somebody who's working illegally for your organisation. What do you think the maximum is for that penalty? When do you carry out your right to work checks at the moment? So when in the recruitment process are you doing the checks? If you are, do you have a license? Just because that has some additional obligations in terms of right to work checks. Do you use the identity service provider for carrying out checks? And finally, just a question about biometric residence permits, whether you use them now and whether you used to use them historically. Just some of the rules have changed, just so we can gauge an understanding of what people are doing at the moment, and then we'll take you through what you should be doing. Just give it a minute for the answers to come in. Okay, we've got most people have now answered, so I am going to end the poll. Apologies for anyone that hasn't finished all of the questions. And I will now share those results so everyone can see. So just working through the questions, we'll deal with it in more detail through the session. But firstly, has anyone ever received a penalty notice? Only 1% of you have, which is not so good for that person or those people, but obviously good to know that not too many of you have had that penalty notice. What I would say, and part of the reason for running this webinar today, is we've started to see an increase in penalty notices being issued. So the Home Office do seem to be focusing more on looking at illegal working and issuing these notices. So it's important to get the right to work checks done correctly. Maximum penalty, so a mix in the view. It used to be a maximum of 15. It's now 45 for a first offence, but it is 60 if you've done it before. So if you're caught more than once, the maximum amount can be 60 and that's per illegal worker. When do you carry out the right to work checks? There's a mix there. No one's saying that they've done it after employment has started, which is good. We will talk through when it's important to do it, but if you don't do it at the right time, which needs to be before the individual starts, then the risk is you haven't got the protection against the penalty. Do you hold a license? So 60% do. For those that do, we'll talk through, there's some additional obligations and things to think about. And certainly there are additional risks if you're not doing it properly. Identity service provider. So Adrian will talk through when you can use these. It looks like there's a mix of results in terms of whether you do or don't. Biometric residence permits. The reason for the question is we have been running a load of mock audits recently, so going out to businesses and checking compliance. And the use of biometric residence permits has been a common issue where biometric residence permits used to be valid information that you could rely on for a right to work check, but they're not anymore. and they also have not been and since April 2022. So I know a lot of people, and 45% of you are saying that you've relied on until 31st December 2024. Although technically that's the date that the residence permit in itself stopped being valid, it has not been valid for the purposes of your protection as an employer since 2022. But we'll look at the requirements in terms of what you should be doing shortly. So in terms of what we're going to cover this morning, it's quite a lot, I'm sure you'll appreciate, for us to get through. So I'm going to talk through why it's important to do the check, what can go wrong if you don't do the checks, the statutory excuse, so the protection you get by doing it properly. And then Adrian's going to talk through the types of checks and practically how you do, whether you do a manual check or a digital check and what that looks like, different types of leave and what you'd be looking for. Then Sophie's going to talk through some mythbusters. So look at some misunderstandings, some things that people may have thought was the case and not, and explain what that looks like. And also look at some trickier areas, things like students, supplementary work, so more unusual situations. And then finally, some employment law considerations, so the issues to be aware of in terms of risk. We're hoping that we will get through everything we want to say in about 45, 50 minutes, leaving some time at the end for questions. If you have questions, please would you use the Q&A box, and then we will pick up as many of those as we can when we get towards the end. Okay, so sorry. In terms of why it's important, the Home Office have said that everybody needs to stop illegal working. Making it too easy, the ability to work illegally is the driver for illegal immigration. In other words, if you are able to work illegally, it's going to encourage people to try to come to the UK to do that. So why do you need to do it? We talked about the fines. If you don't do right to work checks, if somebody works for you illegally, you could face a penalty of 45 to 60,000 pounds per illegal worker, depending on whether it's the first offence. There's also reputational damage. So if you are known as employing people illegally, if you get fined and people become aware of that, it isn't going to be great for your reputation in terms of clients, customers, or even potential future employees who thinks that you don't do things properly. For those of you that have a sponsor license, which is 60% of you, if you don't do right to work checks properly, that is a reason for losing your sponsor license. So if you did ever face a compliance visit from the Home Office and they checked your systems and found that the right to work checks were not done properly, you could find that your sponsor license is revoked as a result of that. The reason for that is that as a sponsor, you are expected to assist in the prevention of illegal working. So you are trusted to have a license and to be able to sponsor people on the basis that you will help with that duty to make sure people are working properly. There's also a risk of criminal prosecutions, fines and imprisonment if you haven't done things properly, if you know that somebody's working illegally, and if you can be shown to be sort of facilitating illegal working and not doing the checks to carry out appropriate checks to make sure people are working legally, then there can be criminal sanctions as well. Extreme examples, if there's flagrant abuse and you're sort of bringing people over without any checks being done, then you could find that your business risks potential closure. If you have a license, so for 60% of you, all of these things are relevant. If you lose your license, you can't just get another one. You have a 12-month cooling off period. And even at the end of that 12 months, you'd need to be able to show that something is different. That means the Home Office should trust you to have another license. So risk is obviously for those of you that have high rates of sponsored migrants, you wouldn't be able to recruit new people. Potentially the people who work for you would have to leave, and then you would struggle to obviously resource your needs. You can have a downgraded license if the Home Office find issues, which means that you can continue to sponsor some of the people that you have, but you wouldn't be able to sponsor anybody new, and you would have an action plan put in place, which would mean the Home Office would be more scrutinising more what you're doing. Your license can be suspended. You may get compliance visits, you may get further compliance visits. So if you have a penalty notice, if somebody's found to be working illegally, then as well as the fine, you can also find that that triggers a visit to come and have a look through all of your systems and processes and finds out everything that you're doing or not doing. And that can then lead to the above issues around revocation, that sort of thing. Now, I mentioned that prevention of illegal working is a requirement, it's a duty of a sponsor. Complying with immigration law generally is something that you are required to do as a sponsor. So even more important for those of you that have a license. But for those of you that don't, it's still important because doing the right to work checks properly can help you avoid the penalty in the first place, which obviously is a financial um, issue. But also, if you ever thought in the future you wanted a sponsor license, if you've got a record of having penalty notices, that could be an issue that would prevent you from getting a license. So in terms of the penalty notice, this £45,000 or £60,000 if you've done it more than once, you can have what's called a statutory excuse, which basically means you have protection against that fine. So even if it turns out that somebody did not have the right to work, so perhaps they've got fraudulent documents, they presented you with what looks like a lovely little visa or passport, but it's all fake or it's not them. You are still protected and you don't get the penalty notice, or you have a very clear defence to the penalty notice if you can show that you've done the right to work check properly. So the government recognises that sometimes people will present themselves with evidence that shows they've got the right to work, but they don't. But provided you've done your checks, you are protected. So particularly important to get this right. And then if you get a penalty notice, all you've got to do is show the evidence of the right to work check, and that will be the end of the penalty. Just please note it doesn't protect you in relation to the criminal liability. So civil liability is if somebody is working for you illegally, and the statutory excuse will avoid that. But if you actually know that somebody doesn't have the right to work, the fact that you've got a nice little copy of a document on file won't protect you. So if you've got knowledge, it's not enough. But if you don't have knowledge and you think they're working legally, then doing the checks will help you. In terms of who you do your checks for, you do it for employees. However, there's obviously some ambiguity sometimes around employment status. So somebody who is potentially a worker or an agency worker could actually argue that they are an employee. So our advice is the safest option is for all workers, whether that be individuals who are on casual work contracts, agency workers, or employees. You do your right to work checks, and then you've got the protection if there's a challenge. In terms of self-employed contractors, you're not required to do a right to work check for these individuals. However, if you have a sponsor license, you should do so. So the guidance was relatively recently updated to say that for those with sponsor licenses, you should check individual self-employed contractors as well to make sure they have the right to work for you. In terms of when, so there's a mix of answers in the poll that we went through earlier about when people do it. The requirement is to do the check before somebody starts work. So not on their first day of employment. That used to be something that you could do, but it needs to be before they actually start. How you build that into your recruitment process is up to you. So sometimes people will do it at the very early stages and ask people to bring evidence or share information for digital checks during the interview process, and that's fine, provided you've got the all of the information that proves the right to work for you. Alternatively, you can make an offer and say that the offer is subject to a right to work, and then they send in or provide the information between offer stage and starting, or people can pop in the day before employment and do it all. It doesn't matter, provided that by the first day of employment, they've actually produced the information, you've done your check, and you've comfortable, you've got everything on your records of what you need to show their right to work. In addition to the check that you do before somebody starts, you also need to diarise any visa dates and any expiries. So somebody, for example, on a student visa may have 3-year visa for the duration of their course. You need to diarise that visa expiry date so that you can then do a follow-up check at the point that their visa is coming to an end. If you take somebody on and sponsor them, so somebody joins you perhaps as a student or a graduate or on some other kind of visa, but then you decide to sponsor them, you also need to do a further right to work check to confirm that that visa has been approved and that they have the right to work for you under sponsorship. So you do another right to work when they get their visa. If there is a TUPE transfer, so if you buy a business or you take on a contract, and as a result of that, you end up with some sponsored migrants moving over to you under what's called TUPE, which is an automatic transfer of individuals, you can rely on the checks that were done by the seller, the previous employer, but obviously sometimes they've not been done properly, or you don't necessarily know what checks have been done. So there is a grace period given. So you have 60 days from the day of transfer to carry out those checks again. And if you do that, you will again have your statutory excuse as if you'd done it before they started work. So you get that little bit longer time to do a check. There is some very detailed guidance from the Home Office, which if you're not familiar with, there's a link at the end of the slides. I would recommend you have a look at. It talks through everything that you need to know, what is and isn't acceptable, practical tips on how to do it, and it is regularly updated. So it's important to keep checking back to that guidance to make sure everything is still as you thought. So the latest guidance deals with checks that you carry out from the 12th of February onwards. So that's how recently it's been updated. So I'm going to hand over to Adrian now, who's going to talk through practically how to do those checks correctly to get your statutory excuse.
Thanks, Kate. Right, so the first thing to mention in this regard are the types of work checks that can be carried out to fulfill that obligation on checking the permissions that individuals that you employ have. And there are essentially three different formats to these checks. The first one, which is probably the easiest one to explain, is the manual check. That is the traditional way of an individual, the employee, before their first day of employment, presents a document which proves their right to work, which is one of the prescribed documents that the Home Office has indicated that it considers acceptable. It is mainly limited to British and Irish citizens. It's not exclusively limited to them necessarily, although what we've seen in recent years is as these lists get updated more frequently, what's tending to happen is that the version of those lists which are acceptable, which I will get on to, really are most relevant for British and Irish citizens, and there are fewer and fewer documents that can be that can be used by non-British or Irish citizens. The second one, which is the one that the vast majority of you will be using when you are employing non-British and non-Irish citizens, is the online check. Again, I'll go into a bit more detail on this shortly. And the third one, which is the newest form, came in 2022, is the Identity Service Provider check. There are a number of, from judging from the poll, there are a number of you who use this. This is suitable for British and Irish citizens only, and it is appropriate for valid passports only. And essentially, this is a third part. This is effectively where you are contracting out the administration of these checks to a third party. So next slide, please. Okay, so manual right to work checks. This is the first one. Okay, so the steps that you need to take on this, first of all, pretty self-explanatory, really. You need to obtain an original document that is mentioned in UKVI's published list on either list A or list B. It must be an original document. It cannot be a copy. It cannot be a certified copy. You must be able to see the original. You then need to check that the documents are genuine. And also, I mean, this may seem fairly obvious, but you need to check that the person who's presenting them is the worker itself. You would be surprised at the number of times people have tried to present ID documents which don't actually show that it's them. And you need to do that in the presence of that holder. So it's no good just having somebody dropping off the ID. You need to check them whilst they are there, either physically or indeed via a video link, as long as you can actually lay eyes on that person. You then need to make a copy of each document in full, and in such a format that can't be manually altered. You also need to make sure that it's clear that the date on which the check took place and who carried it out. So the easiest way of doing that is just to put that on the document itself. And then retention, all copies must be held for the duration of that worker's employment and for 2 years afterwards as well. And that is both when you're looking at a digital copy, when we're doing the online checks, or the hard copy. So just make sure that that's carried out as well. So next slide, please. So the lists of the manual documents that are acceptable, as I've said, this does get updated frequently. And when I say updated, what I ultimately mean is shrunk, as we've seen in the last few years. The list is getting shorter, and this seems to be in line with the government's intention to move pretty much everything online eventually. I think it will come to a point when manual checks are no longer all but gone, possibly with the exception of passports. So there is a list of things on list A. I'm not going to go through them individually, simply because it's much easier, if you do need to consult it, for you to go directly to the source on the UKVI website and have a look at yourself, because any list that you keep may be out of date by the time you need to use it. List A are the permanent documents, so documents showing permanent right to work that do not require follow-up checks, unlike list B. Next slide, please. So list B, there are two lists, list B Group 1 and list B Group 2. And these are when there is essentially a temporary right to work in the UK. And for that, if any of the documents that are being produced are on these lists, then you need to diarise when a follow-up check needs to be done. That's basically the difference between list A and list B. But as I say, do not rely on this list itself. I mean, you know, if or any list that you sort of keep on a file somewhere. The advice is, if you are doing manual checks, always go to the UKVI website and check what the current version of that list looks like, because it does get updated and it does get changed. Okay, next one, please. So what are you checking for? As I've said, this may seem obvious, but again, you'd be surprised the number of times we get queried about issues regarding this kind of thing. So the photos and the dates of birth are consistent, both across various different documents that you might have, and with the person's appearance. It is not all that. It's not unheard of for somebody to produce a document that's not actually them. Now the obvious one is the photograph, but also the date of birth. There is this sort of rather tricky social faux pas where you have to question whether somebody really is that old or not, but sometimes it is obvious. So do bear that one in mind. The expiry dates of the permission to be in the UK, you need to check that those have not passed. So previously, for example, expired passports, expired UK passports, for example, were acceptable proofs, because it was thought that, well, if the passport's expired, it doesn't mean that citizenship has. That's no longer the case. They must be in date. Okay, so you must check that that's there. Check any work restrictions. Some of, particularly the documents on list B, might show work restrictions to ensure that the individual not only can work, but also can carry out the work offered. So there may be restrictions on the type of work that can be done, but that should be fairly obvious on the document itself. Check the documents look genuine and haven't been tampered with. You are not expected to be an expert in fraud or fraudulent practices. You're just simply expected to use your common sense on that. And if there are differences in names, that's not that unusual. If you think about married names and maiden names, do follow that up, for example, with a marriage certificate, or indeed a deed poll or a divorce decree as well, just so that there's an explanation there, as to a formal explanation as to why that inconsistency is there. Okay, next slide, please. Now, the online right to work checks, these are the ones which are used, most of you will use for for employing non-UK nationals. So first of all, you will need to obtain a share code from the employee themselves. You will then use that share code and the worker's date of birth to go to use on the online portal, and you must be satisfied with the photo of the individual, again, that they are that person. And also, the same right to work restrictions as in the physical documents. That should be quite clear from the results of that online check. And again, just like with the physical documents, you must retain a copy of that online result for the duration of the employment plus an additional 2 years. Okay, next slide, please. So here are some examples. This is Erica Musterman. Erica Musterman has the right to work in the UK. As you can see, this is the first example of the result of the online check. He can work in any job, and there's no limit on how long he can stay in the UK. Easy peasy, that. Very, very simple. And then there is also, you can see below, if you employ this person, there are steps to avoid a penalty. It's very clear. It's very black and white. You must check the person looks like the person you've met. You must keep the copy again, and you don't need to do the check again. Okay. Next step, next one, please. This is the second version of Mr. Musterman's permission. In this sense, he has the permission to work in the UK from the 19th of October 2021 until the 19th of November 2023. For the purpose of this exercise, just pretend this is before the 19th of November 2023. If he doesn't have the right to work, it will simply say he doesn't have the right to work. You don't need to check that particular detail. Again, he can work in any job. And again, there is a list there of points to bear in mind to avoid a penalty. Okay, next slide, please. And the third example here, a bit more complicated. In this scenario, Mr. Musterman is a student. He can work in the UK again until the 19th of November 2023, assuming that is in the future. He can work up to 10 hours a week during term time and then full time during the holidays. So there are much more specific restrictions there. Can also work in a placement if it's part of his course, and there is a list of things that he cannot do. He cannot work as a doctor or dentist in training. He cannot work as an entertainer. He cannot work as a professional sports person. He cannot run a business or be self-employed. So again, check that the work that you're offering here is consistent with those points. And again, there is a list of bullet points underneath on how to avoid a penalty. The additional one there is academic dates and vacation dates. And the third point there is the identity service provider. This was introduced in April 22. This is a third party carrying out the checks for you. Be aware that there is a cost to this, and the responsibility and liability still remains with you. You still have to be satisfied that those checks have been carried out correctly in order to avoid a penalty. The penalty liability is not offset in this situation. Okay, next slide, please. And using an ID service provider, the IDSP is acting on your behalf, will provide a response to you in a clear and eligible format in a report way, where you can see the result of those checks, and the employer then would need to carry out your own checks to satisfy that with a reasonable belief that the IDSP has done their job properly. Now, this is probably only really suitable for very large employers with significant administrative burdens to make this worth their while. And again, the check must be kept securely for the duration of the employment and for 2 years afterwards as well. So next slide, please. So the considerations that you need to bear in mind if you are going to engage in IDSP, first of all, find a certified one. Consider the costs. They can be significant depending on how many employees need to be checked. You need to onboard the chosen IDSP, and you need to review your internal recruitment processes to accommodate those as well, and train staff, obviously, on using those too. Next slide, please. So what happens if the worker cannot produce documents or a share code? And we do have scenarios where that is the case, particularly when applications are pending. In that sense, you can use the employer checking service, which is another online tool, which simply enables you to satisfy yourself that there is a good reason as to why these documents or a share code has not been produced, and can give you a statutory excuse of up to 6 months before a further check needs to be made. So usually it is when an application is pending and somebody's right to work is, extended during that period. You need to submit information about the worker online. A response will be provided usually within 5 working days, and then the statutory excuse will be extended again from the expiry of that permission for an additional 28 days for existing employees as well. That's something to bear in mind. You will receive a positive or negative verification notice of that. The negative verification notice, obviously, they do not have the right to work, and a positive one will give you an additional 6 months statutory excuse. Next and final slide, not penultimate slide, sorry, that I'm going to be doing here. So the positive verification notice, as I've said, it confirms work has the right to work. It is time limited for 6 months, and a negative verification notice will mean that they do not have the right to work. And if that is correct, you will need to dismiss. Okay, next slide, please. And finally, just a note on Section 3C leave. This is the permission that a worker has if they have submitted an application prior to their previous permission expiring, but that permission has not yet been decided upon. So that essentially extends the existing permission until a decision has been made in regards to that existing application, and employers should satisfy themselves that a new application really has been made. So a copy of the application or the Home Office acknowledgement through the Employee Checking Service would be required there, and that is ultimately what the ECS is designed to certify. Okay, I'm now going to hand over to Sophie, who's going to talk through the next steps, starting with students.
Perfect. Thank you, Adrian. Okay, so we're just going to be talking, first of all, about students in particular. We're then going to be having a look at supplementary employment, what to do if someone does not have the right to work, and then some of those myth busters that Kate mentioned earlier. So to begin with thinking about students, lots of organisations and employers employ students, but the key thing to note here is that not all students are permitted to work in the UK. So there is perhaps a misconception that if someone is a student, they automatically have the right to be able to work, but that's not always the case. So it's crucial that you do these checks. So students face restrictions primarily on when they can work, for how long, and usually there are stipulated hours for how long they can work in term time, but also in the vacation time as well. Now, students are not permitted to undertake a permanent role, and this is one that often some employers get caught out on. It cannot be permanent because they are still studying, they are still completing their course. And employers need to make sure that they hold a copy of term dates for that student, and that must cover the entirety of their course. So if they are on a 3-year undergraduate course, you need to have the term dates from that institution for the whole of those 3 years. And the reason behind that is really quite simple. It means that you as an employer know when that person is in term time and when perhaps they can work restricted hours, and when it's the vacation time, and perhaps there's a greater leniency on the number of hours that they can work. A final point to consider in terms of students, and again, one that's often overlooked, is it is best practice for employers to actually confirm with the institution that that student is studying where they say they are. Perhaps, it's not as common, but there have been cases that we've been aware of identity fraud, where students are saying they are studying at a particular institution and they are not. So it's always best practice to check that before you actually engage. Okay, if we can go next slide. Okay, so supplementary employment. I'm hopeful that most of you on this call are aware that generally you can employ skilled workers to undertake supplementary employment. And at the moment, workers are allowed to undertake up to 20 hours per week of supplementary employment, and these are sponsored workers, provided that they are still doing the job that they are sponsored for. And that's key, and it's a question that we often get asked. What if the worker is no longer working for their sponsor? Can they still undertake supplementary work? And the answer to that is no. They must still be working for their main sponsor in order to entitle them to undertake supplementary work. Now, if you are engaging someone to do supplementary work, so you are not their main sponsor, but you're just having them for these extra hours per week, what do you need to do? Well, it used to be the case that all you had to do was ensure that they were able to carry out the job that you were offering them, which is all quite straightforward. But the guidance changed in 2024, and there's now particular guidance as to what exactly you need to do to satisfy yourself that that person is able to do supplementary work. So, number one, you need to conduct a right to work check on that individual. Number two, you need to obtain a letter or some other evidence from their main sponsor to confirm that they are employed by the sponsor, what their job description is, what SOC code they're under, and their normal working hours. And the last bit is really key because you need to make sure that if you are offering supplementary work, that worker is only performing that work outside of their contractual hours for their main sponsor. So you shouldn't be offering supplementary work if that's going to cross over when they should be working for their main sponsor. And then the final point, ask the individual to confirm if they're doing any other supplementary work. So you might think you're the only person who's employing them to do this extra work, but you might not be. So ask the question, keep a record of their response, because you need to be satisfied that they are not doing more than 20 hours a week in total, and that's across various employers. Next slide, please. Okay, so you have recruited someone, you think they're going to be great in the role. You've done their right to work check, but what happens if they do not have the right to work? Now, often there is, and understandably, a tendency to perhaps take a bit of a knee-jerk reaction. Panic sets in, and some people think, well, we've just got to terminate them, we can't employ them, and that's often the first reaction. And that might be the case in some situations, but we would always advise that in the first instance, you take a step back and meet with the work in question. Because sometimes there might be situations where they are actually able to produce additional evidence, which will prove their right to work. It just happens that perhaps they weren't aware of documents that they could provide. Perhaps there was an issue with their share code. Perhaps they've got an application pending, so you need to use the employer checking service that Adrian mentioned. So if you can, take a step back, have a discussion just to satisfy yourself that there's no other reason why they cannot produce any documents or a share code or any other evidence. If you've had that discussion and no additional evidence is forthcoming, the worker is not able to give you any reassurance or any documents to show that they do have the right to work, you do need to consider dismissing that worker. And interestingly, I had a call with a client earlier this week where this exact situation came up. Someone did not have the right to work. And their question was, well, can we suspend them? Can't we just suspend them and not give them any shifts? And the answer to that is no. If you are suspending someone, you still employ them. And that's what we cannot have. That does constitute illegal working. So you're thinking about dismissing them. And again, prior to taking that perhaps knee-jerk reaction, consider the unfair dismissal risk. We would always recommend that you seek legal advice in this situation. But if a worker does have, at the moment, 2 years service or more, they do benefit from unfair dismissal protection. So you just need to be mindful that if you're going to go down the dismissal route, we are bearing that risk in mind and we are mitigating it as far as possible. Consider reporting illegal working to the Home Office. And crucially, if you are a sponsor, you need to comply with your reporting obligations. So you will be aware as a sponsor, you have certain things that you need to report within certain timeframes, and you will do this via the SMS. If you are terminating someone's employment, that needs to be reported quickly. So make sure that you're compliant with that. Next slide, please. Okay, so we've got two sides here of some myth busters, some common misconceptions or thoughts, or actually we're hoping to put things right. So looking at the first box, there's often a view that illegal working can only occur if an individual doesn't have permission to be in the UK. And that's false because someone can legally be in the UK, but they don't have the right to work, perhaps because they are time limited. So their visa has set duration of when they are permitted to work, and it's outside of that time frame. But also, as highlighted by Adrian, when looking at Mr. Musterman's results, some people can have conditions related to their visa. So we need to make sure that you are complying with all time limitations and all conditions of the visa. So it's not just if someone doesn't have the right to permission to be in the UK, it can extend to other scenarios. Just to the right of that, we only need to do one right to work check at the start of employment. And again, this is quite a commonly held view. That is incorrect. You need to do follow-up checks, and this is something that Kate mentioned. And these need to be done prior to that visa permission expiring. So on a practical note, we would always recommend that you diarise when right to work checks need to be done again. And if possible, put them in two people's diaries. So if one person is sick, they're on holiday, that deadline is not going to be missed, and you can make sure that there's consistency across the organisation. When actually to do it, you should follow up and do a follow-up check on or just before that permission expires. And what that is going to do is maintain that statutory excuse that Kate was talking about at the beginning, and that's what we want to be doing in this scenario. The very bottom one, if someone shows me their BRP card, their biometric residence permit card, that is enough to confirm their right to work. Hopefully, everyone is clear now that physical BRPs have not been valid documents for right to work checks since April 2022. When Kate launched the poll earlier, quite a few people said that they were still relying on BRPs up until December last year. I understand why that's the case. A lot of BRPs had the end of December 24 as an expiry date on that physical card. And so I can see why that is the case. But if you have or you are relying on BRPs in future, that will not be a valid right to work check. In that scenario, you need to do the online check where the user generates a share code. Next slide, please. Okay, so a few more then. We can perform a right to work check with copy documents verified via a video call. This is not the case. So verifying documents via video call was a temporary measure that was only allowed during COVID. And actually that adjustment, that allowance ended on the 30th of September 2022. So again, you cannot verify someone's documents via a video call. As Adrian mentioned, you need to see that person physically to verify that they are the same person. Similarly, the next one, it is enough to just see a copy of a passport. There's no need to see the person. Well, again, you need to see the original passport. So you need to satisfy yourself that that is the case. But also, you need to satisfy yourself that the person presenting in front of you is the person who you intend to recruit. And there have been situations, particularly if different people are carrying out the recruitment process. So one person carries out the interview and offers that person the job, and someone different carries out the right to work check. It can present difficulties because how can the person who's doing the right to work check know that it's the same person who was offered the job at interview? So satisfy yourself that it is the same person. And obviously, if you have any doubts, undertake further checks. And then finally, students can only ever work 20 hours per week. This is incorrect. Students typically, and quite commonly, there is a restriction that they can work 20 hours per week during term time, but that is not always the case. So please do carry out individual right to work checks on students and make sure that you're paying attention to any particular restrictions on that individual, because they can vary depending on the type of study, the type of course, and of course, we know that the hours themselves can vary as well. Next slide, please. Okay, so touching upon some employment law considerations then. So we've really been talking about right to work checks primarily in this immigration context, but actually immigration and employment law are inextricably linked. So it would be amiss of us not to mention some employment law considerations. So first of all, discrimination. Discrimination is a legal claim, a whole host of legal claims that can be brought in an employment tribunal. And there's always a risk in right to work checks of a potential discrimination claim. So our advice is to carry out right to work checks on all workers to mitigate that risk. And the practical point here is avoid making any assessment of who you think might be a migrant worker and therefore should have a right to work check, because naturally that could give rise to a discrimination claim. So the best thing to do is carry them out on everyone. Everyone is treated equally and consistently. We've then got contracts of employment there, and we've put consider amending your contracts for the employee to warrant they have the right to work. So again, if you are First of all, a sponsor, there's particular considerations we would want to have in a contract. But even if you're not a sponsor, consider having an audit of your contracts. Are they fit for purpose? The reason why we'd want the employee to provide this warranty is because the employee then is providing a promise, a guarantee that they are able to work in the UK. And if that's incorrect, then you as an organisation might have a course of action in respect of any losses or damages that you suffer by relying on that promise. And if you've got sponsored workers, another reason to conduct an audit of your contracts and seek advice if they can be amended and tailored. And the reason why we'd want to do that is because there are some additional clauses that you might want to consider putting in a sponsored workers contract. So, for example, you might want to impart an obligation that they have to update you if certain things change in terms of their circumstances. And the benefit of having that in there is that as a sponsor, you are under reporting obligations. So if the worker themselves is under an obligation to inform you, it makes it easier for you to comply with your own reporting obligations to the Home Office. We've got unfair dismissal on there as well, and we've put consider the unfair dismissal and discrimination risks before dismissing. So again, if you are in a situation where someone does not have the right to work and you are thinking that we need to terminate their employment, we would always recommend you seek legal advice before making that decision. But it can be easy to take that knee-jerk reaction. But if someone does have over 2 years service, at the moment that is set to change under Labour, but currently 2 years service, there is an unfair dismissal risk. So there might be some other considerations that you need to take into account in order to mitigate that risk. And finally, something Kate mentioned earlier, but just a quick nod to it, was TUPE. Kate mentioned that in a TUPE situation where employees are transferring from seller to buyer, for example, the right to work checks that have been carried out by the seller are deemed to have been carried out by the buyer. So the buyer will benefit from the seller carrying out their checks correctly. As Kate mentioned, though, one thing that is key is in a TUPE situation when you've got workers transferring to you, the practical point is, well, how can you do right to work checks because they haven't transferred to you yet? In this situation, there is a grace period of 60 calendar days. So if you are engaged in a transaction where TUPE does apply, you need to carry out fresh right to work checks, but you do have that grace period to allow you to do that. And then finally, just some practical tips, really. So review your practices and procedures. If you are the only person in your organisation who has responsibility for right to work checks, can you teach someone else? Can you bring someone else in the fold? Because again, if you are absent, if you are on holiday, it's always good to have a backup. Review your filing systems. Wouldn't we all love a day to crack on with admin tasks? But this one is really key. So it doesn't matter whether you opt for paper filing, digital filing, both are acceptable. So whatever is convenient for you as an organisation, but make it easy. Make it easy for anyone else who is not you to come into that system and find what they are looking for. Not only will that help internally, but also if you are subject to a Home Office compliance visit, you can have confidence that you've got your filing systems in place and you can pull out the necessary documentation that the compliance officer will want to see. Train staff sounds quite obvious, doesn't it? But train staff on how to practically and properly carry out right to work checks. So make sure that everyone is aligned on the correct procedure. And if there's any queries or problems, what they've got to do. And finally, a really key one, consider an audit. As Kate mentioned at the very beginning of this session, as a firm, RWK Goodman carry out numerous compliance checks. So we will go out to clients and essentially act as the Home Office as best as we can and check your processes, your practices, your systems. You'll be talking to your migrant workers. It's a really key thing to do to make sure that you've got everything in place. Everyone is up to date with what to do and what's going on, so that if you are subject to a Home Office compliance visit, you can have reassurance and confidence that you are acting in a compliant manner. And final slide, please, Kate. Okay, so these slides will be circulated after the session today. We have put a link to some further resources. The UKVI Right to Work checklist, a really easy to follow document, so do check that one out. And again, an online interactive tool which can allow you to check if someone needs the right to work to be in the UK. So these will be on the slides and you can have a look at that. But I think we've just about left 10 minutes for questions. So I think what's probably best to do is if I hand back over to Kate, I can see plenty of questions in the Q&A. So we'll try to pick up as many of those as we can. So Kate, I'll pass over to you.
Thanks, Sophie. Yes, we have questions flying in. We will probably struggle to get to all of them, but I've tried to pick out a few themes as I've been reading them as others have been talking. So there's been a few questions around what do we do if, for various reasons, we've not got things exactly as we've just described. So a few questions around not having the full information around supplementary work or not having done the full checks, and should we do things now? Yes is the short answer. So if you've been relying on physical BRPs when were not valid evidence, or if you haven't got the information for supplementary work from the main sponsor, or if you haven't got the checks that were done at the right time, for example, our advice is that do an audit, find out what your gaps are and fill the gaps now. Now, you can't get your statutory excuse if you do the check now. However, if you do the check now, you can at least find out if there are any particular risk areas. So if you find out there are people who aren't still working for their main sponsor, you can move to dismissal because they don't have supplementary work rights. If you find out people don't have the right to work at all, you can dismiss, and at least you can then take control of that and deal with it before the Home Office discovers somebody is working illegally. So you can't get the protection, but you can mitigate the risk. Another issue that's been raised around the agency worker point that I mentioned. So in terms of right to work checks, you're required to check people who you employ. So technically, if somebody is employed by an agency, it would be the agency's responsibility to do that check. However, if the agency is finding somebody for you to employ directly, they obviously become your employee and you need to deal with the checks as normal. It's also worth having a commercial arrangement where in the terms with the agency, there's some sort of warranty condition, a term that says they confirm they've done their checks properly and you're comfortable that they have, and that they're not just bringing people who don't have the right to work and passing them over to you. If there's any ambiguity over who the employer is, then I would suggest that you do the check. So you're not required to do it if the agency is genuinely the employer and doing it properly, but otherwise I would suggest that you do take steps to make sure these people have the right to work for you. Sorry, I'm just scanning. Adrian, there's a few questions around British passports. I don't know if you want to pick any of those up.
Yes, so a few questions here around the issue of how to prove somebody in the UK has right to work. British passports must be in date. That has changed relatively recently. The old, so-called clipped passports, which are the out-of-date passports, they can no longer be used as proof. That does not mean you have to do a fresh check when those passports expire. A passport, a valid UK passport, is proof of permanent right to work. You only need to do that once, but the passport does have to be in date at the time that you that you check it. There was another question down here regarding how do UK passport holders get share codes. The short answer to that is they do not. The online checking service is for non-UK and non-Irish citizens only. So you do not have to concern yourself with that. Other points here. So
if I just pick up a couple of sponsorship questions while you're scanning through for any others. So there's a question about repeat checks and whether for sponsored workers it's worth doing regular right to work checks, perhaps on an annual basis. Unless you have a reason to doubt their status as right to work, I wouldn't. I think it can, whilst it's good to do checks and all the rest of it, I think you can, if you do extra checks, sometimes it can get confusing and dates can get missed. So do the check before they start, do the check prior to the visa expiry. But I would avoid, unless you're doing sort of an overarching audit and checking everybody for a particular reason, I would avoid just doing lots and lots of checks, because I think, having seen clients that have tried to do that, sometimes what happens is the new check overrides the original. You then don't have the one that gives you the statutory excuse, or things that get misfiled and you haven't got the ones that you need on the system. So I would just do the ones that you need to do. There was another question about compliance visits and whether a compliance officer will look at the right to work checks of non-sponsored staff. The answer is yes, potentially. So what the Home Office want to know is, have you got appropriate systems and processes in place to prevent illegal working? So will you have an appropriate process that means you would pick up people that can't work for you? So they're not just going to be looking at your sponsored staff, they're going to be looking at, how do you check that somebody's got the right to work? How do you check they've got an appropriate student visa, that their hours are capped appropriately, or that somebody on supplementary work is not exceeding their 20 hours a week, that sort of thing. So they'll want to check your process and how you do it generally, not just look at the sponsored staff.
Another couple of passport questions here. I've got a question. Do the online checks for someone from outside the UK, if you're doing an online check, do you still need to provide their passport? In this case, an EU passport? No, you do not. An EU passport post-Brexit is now essentially an irrelevant document for the purposes of right to work checks. So the online checks are an alternative to checking physical documents. Another question on passport is, what if somebody does not have a passport? There are other documents on list A for UK residents, such as birth certificates, as long as that's accompanied by proof of national insurance number as well. So there we go. So I'll hand back over while I scan for a few.
There's one point on the identity service providers. Now, these identity service providers are only permissible for British and Irish citizens. So there's a question asked about a third party that's been doing all checks. So for anybody other than British and Irish, you should be doing the checks yourself in order to get the statutory excuse. So if that has not happened historically, you could choose to run the checks again now to get that sort of protection, to make sure there's no gaps, that the provider hasn't missed anything. Going forward, I would only rely on that identity service provider check to do the checks for your British and Irish nationals, and build in an internal process for doing the checks for everybody else yourself. There was also a question about, how do you do the check in advance of employment when somebody is outside of the UK and moving to the UK under sponsorship or under some sort of visa? So, well, the short answer is, you use the share code. So you can do the digital check, and you can verify, sort of do your imposter check on the share code via a video call. So whilst you can't use the video call like the COVID amendments to look at passports and things like that, you can use the share code and look at that person virtually to check that it looks like them in advance of them joining you.
Just to pick up a few other questions. So a few on supplementary work. One of the questions, can we accept a pay slip from the main sponsor as evidence that that person is sponsored, and then they can undertake supplementary work for us? The guidance states a letter or other evidence. Yes, whilst the pay slip would confirm that they are in employment, best practice says we need confirmation of their hours, their SOC code, their job title, their job description. So in that case, I'd suggest that you gain some more evidence in addition to the payslip, if that's what you're accepting. A question, someone doesn't believe that they have any right to work checks in place. They believe all staff have the right to work, but they've got nothing on file to prove this. Should they do a company-wide check now? Yes. Absolutely. So if you are subject to a Home Office compliance visit and you've got nothing to show that your workers do have the right to work, that's obviously a big risk area. So absolutely undertake right to work checks on everyone, and have, as Adrian was saying, the evidence, the copies saved on file. But happy to discuss further if that person wants to get in touch.
I'm conscious that it's now 11 o'clock. Apologies if we didn't get to your question. There were a lot. If anyone has any particular concerns and wants to get in touch, our contact details will be provided in the follow-up. We will send over a copy of the slides, a recording, and our contact details. If anybody's got anything that we didn't answer and they want to let us know, I'm happy to help where we can. But thank you everybody for attending and for all of your questions. If we can help any further, please let us know. Thank you very much.